judgment in the appeal Bank Mulat against Her Majesty's Treasury.
The Counter-Terrorism Act 2008 enables steps to be taken to prevent terrorist financing and proliferation of nuclear weapons. Pursuant to its provisions, the Treasury made the Financial Restrictions Iran Order, which Parliament subsequently approved. The order effectively shut down the United Kingdom operations of Bank Mulat. The bank applied to the High Court for the order to be set aside. The government took the view that some of the evidence relied on by the Treasury to justify the order was so sensitive that it could not be shown to the bank or its representatives. In the High Court, Mr. Justice Mitting accepted that justice required the evidence in question to be put before the court, and that it had to be dealt with by a closed material procedure, a CMP. A CMP involves the court not merely sitting in private, but considering the material and hearing submissions about it without one of the parties to the appeal seeing the material or being present at the hearing. The excluded party's interests are protected to an extent by the presence of special advocates who make such submissions as they can on behalf of the excluded party. A CMP also involves the court contemplating giving a judgment, part of which will be closed, so that that part is not seen by the excluded party or by the public. A CMP was specifically permitted by the 2008 Act in relation to an application such as that brought by the bank, both in the High Court and in the Court of Appeal. The hearing before Mr. Justice Mitting was partly in open court and partly at a closed hearing. Mr. Justice Mitting handed down an open judgment in which he dismissed the bank's application. He also handed down a shorter closed judgment which was seen by the Treasury but not by the bank and is not, of course, publicly available. The bank appealed to the Court of Appeal, where the appeal proceeded largely by way of an open hearing, but there was a short closed hearing at which the closed judgment of Mr. Justice Mitting was considered. The Court of Appeal dismissed the bank's appeal in an open judgment, and while it referred briefly to the closed material in general terms in that open judgment, the Court of Appeal did not give a closed judgment. The bank appealed to the Supreme Court, and before this court, the bank's appeal hearing was divided into two issues. The first issue concerned the use of a CMP in the Supreme Court, on which I'm about to announce our decision. The second issue concerned the validity of the order itself, on which Lord Sumption will then announce our decision. On the first day of the hearing in this appeal, we concluded, by a majority of 6-3, that the Supreme Court can conduct a CMP where it is satisfied that it may be necessary to do so in order to dispose of an appeal. It's true that the 2008 Act does not expressly sanction a CMP on an appeal to the Supreme Court, as it does in relation to an appeal to the Court of Appeal. However, Section 40, subsection 2 of the Constitutional Reform Act 2005 states that an appeal lies to the Supreme Court from, quote, any order, end quote, of the Court of Appeal. So an appeal must lie in a case where the court below has adopted a CMP. It would not make sense if the Supreme Court could entertain an appeal in such a case without having the power to consider the closed material, and it could only sensibly do so, in many cases, by means of a closed material procedure. The Supreme Court would not otherwise be able to do justice, either in the sense of fairly determining the appeal, or in the sense of being seen fairly to determine the appeal. The conclusion is reinforced by the provisions of the 2005 Act, and by considering the alternative courses of action to holding a closed hearing, all of which are patently unsatisfactory. The minority consider that as a CMP is contrary to the fundamental principle of the common law of the right to a fair trial, Parliament should only be understood to confer the right to conduct a CMP through clear words, and in the minority's view, the 2005 Act falls well short of conferring such a power. Having concluded that we had a power to conduct a CMP, we were faced with an application to conduct a closed hearing in the appeal itself. By a majority of 5-4, we decided that it was appropriate to do so. Despite a strong suspicion that Mr. Justice Mitting's closed judgment would not affect the outcome of the appeal, the majority decided to grant the Treasury's request to hold a CMP because we could not be sure, without seeing the closed judgment and listening to submissions on it, whether the closed judgment would have any effect on the outcome of the appeal. There seemed to the majority to be a real risk of justice not being seen to be done to the Treasury if we did not proceed to hold a closed hearing. The minority consider that the Treasury fell well short of what was needed to show that a CMP was necessary in this case. Having held a closed hearing of around 20 minutes, it was clear to all of us that there had been no point in us seeing the closed judgment because there was indeed nothing in it which could have affected our reasoning in relation to the appeal on the validity of the order. Several conclusions can be drawn from this experience. These are set out in the judgment. In particular, appellate courts should be robust about acceding to applications to go into closed session or even to look at closed material. A CMP should be resorted to only where it has been convincingly demonstrated to be genuinely necessary in the interests of justice. If the court strongly suspects that nothing in the closed material is likely to affect the outcome of the appeal, it should not order a closed hearing.
The proliferation or threatened proliferation of nuclear weapons is an issue of great importance to the security of the United Kingdom and the international community. This appeal is about measures taken by the Treasury to restrict access to the United Kingdom's financial markets by Bank Mellat, a major Iranian commercial bank, on account of its alleged connection with Iran's nuclear weapons and ballistic missile programs. Section 62 of the Counter-Terrorism Act 2008 confers wide powers on the Treasury in situations involving certain specified categories of risk, one of which is the risk of proliferation of nuclear, radiological, biological, or chemical weapons. If the Treasury reasonably believes that the development of such weapons by a foreign country poses a significant risk to the national interest of the United Kingdom, it may give directions by statutory instrument to credit and financial institutions operating in the UK. The most draconian form of direction which they may give is a direction requiring these institutions to have no dealings with a designated entity. A direction of this kind must be explicitly approved by Parliament after it has been made, and pending that approval has a provisional validity of only 28 days. Under the Act, any direction given in the exercise of this power must be proportionate to the risks to which it is addressed. This means not just that the objective of the direction must be sufficiently important to justify the measure, but that the measure must be rationally connected with its objective, must be no more severe than is justified by the objective, and must strike a fair balance between the rights of the designated entity and the interests of the community. On the 9th of October 2009, the Treasury made an order under the Act, subsequently approved by Parliament, in which they designated Bank Mellat and directed that all financial institutions in the United Kingdom should have no dealings with them. Bank Mellat owns, jointly with another Iranian bank, a UK subsidiary called Persia International Bank, through which it previously conducted a substantial trade finance business in the United Kingdom. This business was brought to an end by the direction. The order automatically expired under a sunset clause after a year, but by then the bank had been made subject to a general asset freeze under European Union regulations directed against the Iranian weapons programs. The bank has embarked on a number of connected proceedings in the courts of both the United Kingdom and the European Union with a view to having the various measures taken against it set aside. In January of this year, the bank was successful in having the European Union measures against it annulled in the General Court of the European Union, although the measures in question remain in force pending an appeal to the Court of Justice of the European Union. This appeal is concerned with the bank's attack on the United Kingdom measures. Apart from a common factual background, the issues in the European courts and the United Kingdom courts are different. Under the Counter-Terrorism Act, a statutory right is conferred upon any person adversely affected by a Treasury direction to apply to the High Court to set it aside and quash the resulting order. In November 2009, Bank Mellat made such an application on two grounds. First, they contended that the procedure adopted by the Treasury was unlawful because they had had no advance notice of the Treasury's intention to make the direction and had had no opportunity to make representations about it. Secondly, they contended that the directive was unjustified because, among other reasons, it was disproportionate and discriminatory. The judge, Mr. Justice Mitting, rejected the bank's application on both grounds, and the Court of Appeal, by a majority, agreed with him. In the Supreme Court, the bank's appeal was heard by a board of 9. The Supreme Court, by a majority, allows the bank's appeal on both grounds and quashes the order. The majority's reasons on both grounds are set out in a judgment which I have prepared. I shall first summarise the Court's reasons for concluding that the order was unjustified because it was discriminatory and disproportionate. No one doubts the importance of the Treasury's objective, namely to inhibit the procurement internationally of materials, equipment and services required for Iran's weapons programs. No one doubts that Iran's international procurement operations depend on a variety of services, including trade finance and money transfer facilities provided by banks. The essential problem about the Treasury's direction was that it singled out Bank Mellat without rational grounds. Iran has a large banking sector with access to an even larger network of correspondent banks. It includes 5 commercial banks with a substantial presence in London through UK subsidiaries. The direction was originally made and justified to Parliament primarily on the ground that there was a particular problem about Bank Mellat which did not apply to the generality of Iranian banks with significant dealings in London. The contention, which was expanded in the Treasury's evidence in the proceedings, was that the bank had among its clients a number of organizations and individuals associated with Iran's weapons programs, some of which had been included in a blacklist of such organizations and individuals annexed to successive United Nations resolutions concerned with Iran's weapons programs. The judge did not accept this part of the Treasury's reasons. He found that Bank Mellat had in place a mechanism which it operated conscientiously for ensuring that it did not provide banking services to entities blacklisted by the United Nations. Of the organizations and individuals identified by the Treasury as having received banking services from Bank Mellat, the judge found that one had had its banking relationship terminated once it appeared on the United Nations blacklist, while the other had been investigated by the bank for nuclear-related activities, but nothing suspicious or unusual had been found. Allegations were made concerning 2 individuals said to be officials of an Iranian organization involved in the programs, but the evidence was inconclusive. That left as the only justification for singling out Bank Mellat the more general concern that the bank might unknowingly or unwillingly be the instrument by which Iran's nuclear procurement transactions were settled. This was a risk inherent in the provision of banking services, however careful a particular bank may be. But the judge and the Court of Appeal considered that it was enough to make the Treasury's order rational and proportionate. The Supreme Court disagrees and concludes that a consideration of this kind, which is common to the whole banking sector, cannot justify singling out one bank for designation under this particularly severe form of order. Moreover, in circumstances where, as the government itself pointed out in Parliament, it remained open to Iranian organizations and individuals to transfer their business to other banks, to which exactly the same considerations would in the nature of things apply, it is difficult to see how the direction could have any impact on the Iranian weapons programs substantial enough to justify the serious damage inflicted on Bank Mellat's business. Turning to the bank's complaint about the procedure followed by the Treasury, it is one of the oldest principles of English public law that where a governmental or administrative measure is targeted against a particular organization or individual and is liable to cause it serious harm in its enjoyment of its rights or property, there is a duty to act fairly, which will normally require that the target should have an opportunity to make representations before the measure is taken. This rule is not absolute. It will not apply where it is impractical to give advance notice to the target or would defeat the object of the measure, for example, by enabling the target to take evasive action. However, the judge found that there was no practical problem about giving advance notice to the bank and that advance notice would not have enabled them to take any evasive action which they could not have taken anyway after the order was made. In this particular case, this is very much more than a matter of form. If Bank Mellat had had the opportunity to make representations before the order was made, they would have been able to give the Treasury information about their dealings with the organisations and individuals that had aroused the Treasury's concerns in much the same terms as the judge later did. If they had had that opportunity, it is unlikely that the measure would have been presented to Parliament in the way that it was. These problems are not likely to arise very often. The government, as both the majority and the minority of this court agree, is entitled to a very wide margin of judgment in dealing with the delicate matters of international relations, calling for an exercise of judgmental assessment and experience in a specialized field. However, the measures taken against Bank Mellat in this case were vitiated by a demonstrably unfair procedure and by a number of significant misconceptions about the facts. In the result, the Treasury's decision to designate Bank Mellat and require UK financial entities to avoid dealings with it must be set aside and the resultant order quashed.